If you've been charged with a domestic assault here in Virginia and the complaining witness, the person that's alleging that you assaulted them, has said to you, I don't want to go forward with this case, and you're wondering, can I rely on that? Is the charge automatically going to be dropped? If that's the situation that you're in, make sure to watch this video. Hey folks, James Abrenio here, owner of Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. In this video, I want to talk about a scenario that I get calls about often. People will call me and tell me that they're charged with a domestic assault and the complaining witness, either a significant other or a spouse or somebody in close relationship to allow the domestic assault charge, has told them, hey, they actually don't want to go forward with the case. James, there's not a whole lot for you to do because I'm pretty sure the case is going to be dropped. This video is meant to educate you about those circumstances, especially if you're facing it, and what may happen. So in order to do that, we've got a few graphics. So the first one is, no, there's no guarantee that the case will be dismissed. And I want to be clear about that. Even if the complaining witness has told you that he or she doesn't want to go forward, you can't simply rely on that. Now, why is that? Now, first of all, at least here in Virginia, the Commonwealth's attorney, the prosecutor, that's what we call him here in Virginia, represents the community. They don't represent the complaining witness. They don't represent you. They represent the community as a whole. And there is without a doubt an issue with domestic violence in Virginia and across the United States. Prosecutors are rightly concerned about domestic violence victims getting law enforcement called out, law enforcement coming and properly charging somebody, but later on the accused, the person that has allegedly assaulted this person, is now pressuring them not to go forward, either directly or indirectly, and so the complaining witness no longer wants to go forward, and they're essentially left in an abusive relationship, and the law enforcement and the Commonwealth can't do anything about it. So they're going to be suspect about all cases where a complaining witness has said, I don't want to go forward. And the reason being, to call law enforcement, to get police on the scene, for there to be enough evidence, alleged evidence for a charge to issue, a prosecutor is going to always be concerned about whether or not a case is just being dropped because the complaining witness is being forced not to come forward. Now, I want to be clear, of course the complaining witness has rights, but it's ultimately going to be the Commonwealth attorney's decision about whether or not to go forward with a prosecution. They're going to, in most cases, consider what the complaining witness is telling them, but I can't tell you how many cases that I've dealt with where a complaining witness didn't want to go forward with the case, and the prosecutor has forced me to put the case on and proceeded with that prosecution against the complaining witness's desires. Ultimately, at least in my view, is the bigger question is going to be whether or not the complaining witness can actually secure a conviction against you with or without the complaining witness's cooperation. Can they win without needing the complaining witness to be fully on board with the case? Now, how can the Commonwealth win against the complaining witness's wishes? Now, first of all, they can actually force and compel a complaining witness to testify. And what I mean by that is they can subpoena them to court, they can call them to the stand, and they can ask a judge to compel that individual to testify. In instances where that individual won't testify, a court can hold them in contempt for not willing to testify. And the theory behind that is people are called to as a witness, they have a duty to tell the truth, and if a fair question is asked, the court has a requirement to force them to answer that, to compel that answer. Now, I've had situations where this has happened. I've had many trials where witnesses don't want to go forward and then they're compelled to testify. Now, some people ask me, in many instances, they'll say, well, how can they do that? How can I, as the accused, how is that possible? It seems unfair. How, and not even the accused, but the complaining witness, how can they force me to testify? And what I'll say is that's kind of the way it works. And unless there's Fifth Amendment issues, the complaining witness may very well be compelled to testify. Now, what I mean by Fifth Amendment issues, under the Constitution of the United States, you as a citizen, and even non-citizens, have the right to not be a witness against themselves. So if law enforcement, even in court, if you have a Fifth Amendment concern that you may actually inculpate yourself or incriminate yourself, you can plead the Fifth Amendment and they can't force you to testify. But there are other situations where the complaining witness's testimony isn't even necessary. And the main one that I can think about is when a defendant is interrogated by law enforcement, or not even interrogated, but just questioned, and they confess to an assault. And then the court finds that there's slight corroboration. Now, I think anybody that has been paying attention to criminal justice reform and all of that recognize that what is deemed a, quote, confession is always suspect. So sometimes statements are either coerced or they're misconstrued. And so an issue whenever we're looking at this next prong about a defendant confessing and there being slight corroboration is as well, what was actually said to law enforcement, under what circumstances, are those admissible? Is there potentially a Brady issue or a right to be advised of your rights, improper interrogation, a coerced interrogation, that kind of thing. So the first issue is whether or not the confession, the alleged confession, is actually admissible in court, and whether it's actually a confession itself. The other thing is what is slight corroboration? That's a question I get a lot, and it's not honestly well defined by the court, the statutes, cases. Slight corroboration for one judge may require that there be a photograph of injury. For another judge, it may be, hey, there's a cup that's against the ground that was before on the table, and that may be enough for them to say that that's slight corroboration of domestic assault. So now the next slide is, so what do you and your attorney need to do in order to prepare if you've been charged with a domestic assault? And in these situations specifically where the complaining witness has told you she or he doesn't want to go forward. Number one is you need to be forthcoming with your attorney to make sure that attorney knows all the facts. Just like any case, you don't want to be in a position where your attorney has their hands tied because they're not aware of certain facts that may change their analysis. The next thing is you need to assume that the case is going to go forward, and you need to prepare for trial as such. In most of my cases, where there's any opportunity at all, even in a situation where the complaining witness says they don't want to go forward, I will still have the accused come in. We will go over trial evidence. If they're going to testify, we'll prepare for that, and we'll be ready for trial, because I never want to be in a situation, and I've had this situation where a complaining witness says they don't want to go forward. Then when we get to court, all of a sudden that changes. So I don't want to be left flat-footed. Don't discuss your case with the complaining witness, and especially about whether or not he or she is going to testify in court. Because if that happens, the Commonwealth is rightly going to be suspect. They're looking for witness tampering. They're looking for, as we talked about at the outset, domestic violence victims, true domestic violence victims being compelled not to testify, or coerced or urged not to testify by the accused. And I, as the attorney, don't want to be in the situation where I have to convince a prosecutor that you didn't try to coerce this complaining witness into not testifying. And the way you do that is you go and you start telling the complaining witness you want the charge dropped, you'll do anything to get the case dropped, all those kinds of statements, even if it's in theory innocuous and you're not having malintent. That may very well be interpreted. And if you do have malintent, I want to say, if I find out that happens in a case like mine, you're getting fired. My instruction to you, if I ever represent you, is you never are be in a position where you're trying to influence testimony. And if you put me in a position where you've went against my wishes for something like that, that violates one of my values, and that's having clients that follow the instructions, and I'll have to let you go. And do everything your attorney asks. We don't ask our clients, at least I don't ask my clients to do things just for the fun of it. I don't ask for you to do community service. I don't ask for you to engage in anger management courses or therapy. I don't do that because it's going to be fun. I don't do it just to entertain you. I do it because, first of all, the circumstances may very well call for it. Maybe even if you're not guilty of an assault, the relationship that led to a domestic assault is so bad that either you need therapy or guidance to recognize that you're in an unhealthy relationship, or the relationship is so bad that you need therapy in order to be able to cope with the issues. Community service, in my view, if I'm asking for it, it serves the community, but it also demonstrates to the court that you're taking this seriously. So listen to our advice, and you're going to be putting yourself in the best position to get the best result at court possible. No guarantees that anything that you do that we recommend is going to lead to an acquittal or a drop of a charge or anything like that. But our goal as counsel is to put you in the best position for a good outcome or the best outcome. So we don't ask for these things lightly. Now, if you have any other questions, make sure you can reach out to us. You can comment below. You can reach out www.abreniolaw.com. Phone number is 703-570-4180. My email is right there. If you have any questions, make sure to reach out. Our goal at Abrenio Law is to educate the public, even if you're not a client. If I get a good question, oftentimes that's what spawns me or inspires me to create videos. So feel free to reach out. If you have a question, I may very well shoot a video on it. So thanks a lot for watching. Take care, and thanks a lot.